Criminal Session number 335 of 2025, Uganda versus Karua Dr. Besigye, Ajobed Utare, and Captain Denisola.
Council Bayan Tudinawi. Council Savard, that is Bayan Tudinawi. And Kwagala Isaac.
Council
Bayan Tudinawi. My Lord, after talking to our clients, we wish the court to register that the plea taking is an ambush, because we came to court for bail ruling, which was to be given through the... Sorry. Okay, sorry. We came today for ruling on stay and bail, which initially was to be delivered via email. The instructions from the court changed and we were told to appear today for ruling, and that's what we were coming for. We think it is manifestly unfair to ambush the defense. We also wish to register our concern that politicians in government and in the highest office appear to know the verdict or what is likely to happen, which has been in the press that no bail will be given. And in view of the fact that justice should not only be seen to be done, but be seen to be done, that is of great concern and is something that is likely to cause less faith in administration of justice, as the question will linger whether the court, and in particular this court, is acting on its own or there are other strings being pulled. That having been said,
I am saying avoid those situations here. See it on there? Start situating here.
it is my duty to voice the concerns. It's been in the media.
I am the one handling this case. I am not handling the media.
So maybe then you may wish to issue a caveat to politicians in government, including the highest office, to stop commenting on this
I have
case.
no problem with that if you make that.
Yes, I am urging the court, therefore, to put a stop to pronouncements that are likely to prejudice the hearing of this case. That was the whole object of bringing that in, because it's of great concern. Otherwise, having noted our objections, and my colleague Elias Baguma has a few observations to make before the court.
My Lord, in addition to, first of all, I agree with the submissions made by the Senior Counsel Karua, but we would like to add that, my Lord, that it will be regular. My Lord, to proceed with plea-taking when the instruction is given to us, my Lord, they were restricted to receive the ruling. The amount, my Lord, to Besigye represent their chosen persons in a matter where they yet receive instruction. Bearing in mind, my Lord, that is mandatory under the Constitution for the accused persons to be effectively represented. And my Lord, effective representation presupposes, my Lord, interaction with the accused persons, have an interaction between lawyers and the accused persons. To prepare for that particular process we are about to embark on of B.Tech. And we have not had that opportunity. My Lord, we have a duty, we owe duty to the accused persons to advise on the nature of the good they are going to make. We owe them a duty. We also owe a duty to this honorable court to facilitate that process. Yeah. We want to go on record, my Lord, that we are inadequately prepared for that process. Ultimately, my Lord, if we proceed that way, my Lord, the final one is about the irregularity. I mean, the propriety of the proceedings, the propriety as well. Because, my Lord, there is a pending bail application by order. That is a FE. When we last appeared here, my Lord, when we last appeared here, the indication was that it was adjunct to defamation. And good enough, counsel for life is here. And my Lord, procedurally it would be improper to proceed with a substantive session case in disregard or total disregard of the pending miscellaneous application. My final one, my Lord, to section 61 of the PI, section 61, which I will read, my Lord, for emphasis sake. The accused person to be tried before the High Court shall be placed at the bar unfettered, unless the court shall cause otherwise to order. And the indictment shall be read over him or her by the chief registrar for the office of the court, and explained, if need be, by that officer or interpreted by the interpreter of the court. And the accused person shall be required to plead instantly to the indictment. It's probably immediately as good. Just want to look at the proviso now, because that's where my submission is in the proviso. Unless where the accused person is entitled to service of a copy of the indictment, he or she shall object to the want of such service, and the court shall find that he or she has not been duly served with the copy. My Lord, the issue is about the service of the indictment on the accused person. if indeed this matter had been fixed for retaking today, it would have been preceded by service, copied, signed, and served on the accused person well in time, and would have that opportunity to discuss it. And then the accused person will become here prepared whether to plead guilty or not. But this was not done now. In the circumstances, my Lord, we pray that you be pleased to adjourn the matter. For that particular purpose, we do so. We therefore object to the retaking of the matter.
Today we are prepared to present the bill application of evidence Ola. The sureties are here. They have traveled very long distances, that is from Hulu. The last time they traveled, there was no travel today. One of the guide, which I do know it is your discretion, we are so prepared to proceed with the bill application for Captain Dennis Oyakola. Another issue, my Lord, we have, we did present it to you. We've had the leverage to look at the indictment that you are yet to read in this honorable court. The concerns we raised last time are the concerns we wish to retaliate. That the indictment misdescribes the accused person in material manner. It wrongly mentions his name, his age, and his area of occupation. Section 23 of the trial TIA coaches in mandatory terms that the indictment shall be specific to the particulars of the accused person. The indictment, whereas they have not yet been served a signed copy, the indictment does not, as read earlier, that it shall be handled today or the time when they are going to plead. It still misdescribes the particulars of Captain Dennis Oyakola. Well, you can mistakenly argue that this is a minor clerical mistake. We point out that this is fatal, incurable, and if Ola proceeds to plead today, we shall be left with no option in the capacity of A3 is Captain Dennis Oyakola, and the person that states, and I know just to be on record, the state has been in custody of the particulars of A3 So if the person they intend to charge is the one they have on indictment, then the person before court in capacity of A3 is a very different person. So my Lord, if it is your guidance, or if it is your direction, that A3 goes ahead and plead, it shall so much violate his right to a fair hearing. In that spirit, we humbly pray that Allah is accepted, or that you give him audience to hear his bail application, and let the state be given time to trace the person they intend to indict. Because the person they intend to indict is not the person in capacity of A3. So pray, Lord.
Always been ready. This matter proceed with plea taking, and my Lord will therefore humbly await for court's guidance on this. My Lord, we are also, the prosecution is also alive to the concern, the legal concern raised by a land friend, Simon Osubuta, on behalf of A3, that indeed the particulars of the accused person must be specific and point to the person in court. My Lord, the prosecution undertakes to amend the indictment in terms of the name, the age, and the occupation of the accused person before court. And we be pleased to have this amendment filed in court. My Lord, this will happen after they have been served with the indictment that is presently before the court.